The following is a paid presentation by Siniard Law Injury Attorneys, paid for by Siniard Law Injury Attorneys. The Siniard Law Show, answering your legal questions, featuring attorneys Tommy Siniard, Bart Siniard, and your host, Aaron Dacey. This is the Siniard Law Show.
Hello and welcome to the Siniard Law Show, where we invite your legal questions and educate you on various areas of the law. Siniard Law is a father-son personal injury firm right here in the Tennessee Valley, focused on giving back to the community through legal education. Siniard Law has again received recognitions as a Tier 1 personal injury firm by Best Lawyers in America. Tonight, we're discussing personal injury law. Bart Siniard is joined by another attorney in their firm, Harrison Lane. Good evening, gentlemen.
Good evening,
Good evening.
Aaron.
Tell us a little bit about personal injury.
Well, that's really what our law firm focuses on. So this will be an easy show for us. We, deal with this day in and day out. Harrison's with us, associate at our firm. I want to brag on Harrison a bit. He just got named one of the top 40 under 40 lawyers in Alabama by the National Trial Lawyers. So really proud of that for you.
Well, thank you. Yeah, it's a great honor. It kind of ages me a little, but at least I'm under 40, so I'll take it however I can get it. But it's a great honor. I know Bart's received it, Tommy, even Barnes, all of the attorneys at our firm have. And so it's nice to be a part of that as well and to get that recognition.
Absolutely. We're proud of Harry, and as we call him, Harrison is his lawyer name, but I call him Harry. But anyways, we're excited to jump into this and answer some viewers' questions.
All right, sounds good. And if you have any questions on this topic or any other legal topic, just email us at questions@siniardlaw.com or call us at 844-7000-LAW. And your question may be featured. Now to our legal tip of the week, understanding statute of limitations. So what is this?
Yeah, this is what everybody has to be aware of. And it's not just personal injury cases. It's any type of legal claim or legal matter has a statute of limitations. And basically what that means is there's a time limit in which you can do something legally to try to resolve a dispute. You can't just sit on your hands for years and years and years and not do something about it. The legal system throughout America has statutes of limitations where it says, we don't care how great of a case you may have. If you haven't brought it by then, it's over. And that's what a statute of limitations is. It's like a game clock. If in a basketball game, if you haven't got the shot off by the time the shot clock goes off, it doesn't matter. If it was nothing but net, it doesn't matter. It's too late. So that's the analogy I give clients. Statute of limitations in Alabama, specifically where we practice, first off, personal injury, what we handle. Harry, walk us through that. What are the statute of limitations in a personal injury case?
Well, what's funny is it's not always easy to answer, right? A lot of it is fact specific as to your case and what that looks like. So when you talk about an injury case, an injury claim, what does that look like? Well, the typical deadline for that is going to be 2 years from the date of the injury. But again, if you're injured on the job, it may be different. You may have more than 2 years. But at the core of it all, 2 years is what we go off of. And as Bart can kind of allude to, though, there are ones that are even shorter than that, or deadlines that have to be met well before the 2 year deadline. You want to talk on that?
I mean, so usually the general rule is 2 years in Alabama for a personal injury claim. If the accident happens in Tennessee, it's actually 1 year. So you got to keep that in mind. Some of our viewers are across the state line or may have been in an accident, up in Fayetteville or Pulaski. It's 1 year in Tennessee. But in Alabama, it's usually 2 years. But like Harrison said, it can be shorter if a county or a municipality is involved. For example, if a city dump truck rear ends you, whether it's, doesn't matter which city in Huntsville or city in Alabama, a dump truck hits you, you only have 6 months from the date of that incident to file a notice of claim with the city clerk treasurer. And if you don't file that written notice of claim at Municipal Hall within 6 months, then your claim can be barred. So if you get in an accident where you think the city's at fault or a county's at fault, it's different. It's 6 months for a city. For a county who caused an incident, it's 12 months. So it can be shorter than that. There's also situations where it can be extended past the 2-year window. Like Harrison alluded to, in a workers' compensation claim, when people are hurt on the job, it can be extended 2 years from the last date they received a temporary total disability payment.
Wait, go back. Say that again.
Yeah, it's kind of complicated. But like in workers' comp, when you're out of work on doctor's orders, you've had to have a surgery and you're not ready to go back yet, workers' comp sends you checks that's for 2/3 of your average weekly pay. And the statute of limitations in a workers' comp case is 2 years from the date of that last check.
Gotcha.
So we've had clients been out of work 1, 2, 3 years or permanently out of work. Their statute of limitations is extended because they're still receiving those checks. Another situation, and I'll let you talk about this, is when you have a minor, how the statute of limitations can be extended.
Yeah, so when you have a minor and you're under the age of majority in Alabama, which 19, now 18 contractually, but that's a rather new law. What you see is that a minor cannot consent to a settlement agreement. That is a contractual agreement until they reach the age of majority. Now, there are certain aspects of it where a claim can be resolved for a minor prior to them reaching the age of majority, but it tolls in that statute. That 2-year deadline doesn't start running until they reach that age. Yeah. So what you end up seeing a lot of the times is the claim is handled within a 2-year window, because waiting 18 years to find evidence is going to be really hard to find anything.
Yeah. And so, we handle a lot of cases where children are injured, whether it's in a car accident or, at a trampoline park or whatever it may be. The timeline to resolve those claims is much longer because it's not fair to impose on a child a statute of limitations until they're no longer a child.
But you want to collect the evidence.
Oh yeah, no,
possible,
it's not
right?
it's not like we're going to sit around and wait years because we don't.
Yeah, by that time the trail's gone.
Oh yeah, no.
Probably. I mean,
yeah. We that's the first thing we always do is try to collect evidence.
Now, what about if somebody is injured but they feel like they don't have any injuries? So in other words, they don't know, and so they say, well, I'm just going to wait for a little while because I'm not really hurting.
They say pride is a sin. Yeah. So, I typically tell clients, let's not be too prideful. I'm not a medical doctor, and outside of the rare occurrences, our clients are not medical doctors. So we don't know what your injuries are until you can get properly evaluated. So after you even think you've been injured, that's not really the time to be prideful and think, I'm just going to go back to work and I'll worry about it later.
Yeah. I get that all the time. People are like, oh, well, I've been talking with the insurance company for a year. Doesn't that extend things? Or I'm still having to get medical treatment. Doesn't that extend my statute of limitations? No, it doesn't. The statute of limitations doesn't care why you haven't filed a lawsuit or reached settlement.
And just because you investigated doesn't mean you would necessarily file a lawsuit, right?
No,
I mean,
no.
So
your case has to be
cover yourself.
Statute of limitations means a case has to be settled or a lawsuit has to be filed within that period. If neither of those two things has happened, your case is over, you lose, it does not matter.
So it's better to say something right at the front end.
100%.
Okay.
Absolutely.
All right, well, let's get to our viewer questions. This first question tonight comes in an email from Hannah. She says, I am writing to seek urgent information and potential guidance regarding a professional malpractice claim in the state of Alabama. The incident pertinent to this inquiry occurred on September 30th, 2024. Given this context, I'm particularly concerned about the specific framework for filing a malpractice claim in Alabama and whether my opportunity for legal action remains valid.
Yeah, so Hannah's talking about a professional malpractice claim that could be against a doctor, it could be against a lawyer, could be against an accountant. But in any of those situations in the state of Alabama, it's 2 years from the date of the alleged negligence. So September 30th, 2024, that's the date she's given us. She still has time. The statute of limitations would expire on September 30th of this year. But I always tell people, you don't want to wait until, a month before the statute of limitations gets here before you call a lawyer. Particularly, we handle a lot of medical negligence cases against nursing homes or hospitals. And there's a lot of work that a lawyer needs to do before filing a lawsuit. And we have people call, it'll be a week before the statute of limitations, and I'll be like, I can't take your case.
You've got other cases, or you've got a lot of work.
Well, and walk them through all the stuff in a medical malpractice case, all the stuff we have to do.
And a lot of it, Aaron, kind of as you alluded to, is one, we are very busy throughout the day, but we make time to meet with people who have a claim or maybe have a potential claim or just want answers. But the big issue is we have to, in a medical negligence sense, medical malpractice, we've got to get the medical records. Mm-hmm. An overwhelming majority of that case is going to be what is within those medical records, and in some instances it is what is not in those records. But we have to have enough time to look at those, review them, get them to an expert for an expert's review, and then get their opinion back. And sometimes that alone could take over a year, just depending on the situation that you're looking at. So it's very important that people get to us early on so we can start, as we kind of talked about all night, start gathering evidence.
Yeah. There's a lot more work that goes into, I call it the homework phase. Before we go out and launch into, a full-blown lawsuit, particularly in a complicated case, we really want to do our homework, hire expert witnesses, review all the documents that may be evidence in a courtroom someday. And if it's a rear end car wreck case, it's okay to call a lawyer, the week before. But if it's something, more complicated where there's going to be a lot of, unique legal or medical issues, go ahead and give that law firm a call now instead of thinking about it for the next, 6 months.
This is probably a good time to remind people too that you will speak with anyone. Mm-hmm. And that might not even cost them anything for you to just speak with them about whether they have a case or not.
Yeah, I mean, it's absolutely free. We do free consultations for anybody who reaches out with an injury, right? It doesn't cost you anything to have us speak with you, let you know what your options are, but it also doesn't cost you anything to have us represent you. So it's kind of a risk-free trial. I mean, even if you're just looking for answers or advice as to what to do, we meet with people all the time. It doesn't necessarily mean that we take their case, and it's not because they don't have a case, it's just they don't need an attorney at this point. And a lot of those people may come back at some point in time, but we're more than happy to sit down and go, look, this is what we know, here are your options, and discuss it with them.
Yeah.
All right, let's get to a voicemail.
So I was in a car accident recently. Luckily, I was fortunate enough that I wasn't badly injured, just some minor cuts and scrapes, but I'm thinking about handling the claim on my own without a lawyer. I've read that hiring a lawyer just really eats into your settlement amount and that most time it's not really needed. In your opinion, in what situations would I need to hire a lawyer? And do you think this sounds like something I might be able to handle on my own?
Some personal injury lawyers will get mad at me for saying this on air, but there are some situations where people can handle their own car accident in personal injury claim. If it's relatively straightforward as to who's at fault, the other person has an insurance company that's easy to work with. There's only two. I won't say them on air. The rest of them are difficult to work with. And if your injuries aren't terrible, there's no surgeries, no fractures, you can work it out getting a fair amount. And I've actually written a book on this topic that I give out to people for free, how to handle your own injury case. 'Cause some people, I think, if they're intelligent enough, tough enough, and have enough persistence, they probably can do it on their own. The vast majority of the cases, people can't. It's because it's either too complicated, the injuries are too severe, or the insurance company they're up against is difficult. And that's the majority of them that are difficult. But I've met with people that, I try to just teach them the A, B's, and C's and say, I think you can do this. No lawyer's gonna pressure you though or at least we aren't, to sign anything and let us handle the case. You can always call any personal injury lawyer and say, hey, I'm just looking for some advice. I do that all the time. And I'll spend 5 or 10 minutes with you on the phone and say, well, here's what you need to do next. If you run into a roadblock, call us back. They usually do end up calling us back a month or two later, but we'll talk with you for free and walk you through what you need to do if you're a little hesitant to hire a lawyer.
All right, sounds good.
And I would just mention as well, though, that part of the question, too, is the fact of, like, when do you need one necessarily? But the fact of the matter is, and we tell people this all the time, this is what we do for a living, right? Everybody has different jobs. We help people who are injured, and a lot of people will call and think my case isn't big enough for y'all to handle it, and that's not always the case, right? We encourage people to reach out to us because this is what we do. We help people who have been injured, whether it's big or small, but sometimes in certain instances, we can guide you through it without there having to be any kind of fee for us.
Yeah.
Thank you both very much. And when the Siniard Law Show returns, we'll get to more of your legal questions and we'll tell you how you can sign up for their free monthly newsletter.
Harrison Brothers brings together the best of North Alabama. Our curated selection of local art, fine crafts, and gourmet food are great gifts for everyone on your shopping list. We carry books by local authors, and our toys pique a child's imagination. At Harrison Brothers, your purchases support artists and artisans right here in the Tennessee Valley. Located on Huntsville's Courthouse Square since 1897, Harrison Brothers is more than a store. It's a tradition.
I got sandwiched between an 18-wheeler and a truck. During the accident, I lost my left leg. I chose Siniard Law because my granddad knew they had a great reputation. They were very knowledgeable. They were very sweet. We had a connection. They pretty much treated us like family. I would definitely recommend Siniard Law because they are caring and they will help you get what you deserve. If you've been injured, call Siniard Law.
Welcome back to the Siniard Law Show. If you would like to sign up for Siniard Law's newsletter, which provides free monthly legal tips, just scan the QR code and be sure to sign up at siniardlaw.com. Now let's get back to you, our viewers, and your questions. We have an email from Jeff. Jeff says, I enjoy your show on 48 in Huntsville, Alabama. I am thinking of replacing standard bulbs in my car with brighter bulbs, either halogen or LED. I see neither is DOT approved. Does this increase my liability in case of an accident? This is a good question.
Yeah.
I've seen those those headlight bulbs. They can be really bright.
Well, yeah, Jeff, I appreciate your kind comments about the show. And, you know, this is really the first time I've had this question. You know, I don't know whether he's a commercial vehicle operator or just me or you driving our personal vehicles. So that would be one thing I'd ask before I really wanted to provide an answer. If he's a commercial vehicle operator, like he's driving a company delivery vehicle or an 18-wheeler or whatever, then they have to strictly abide by the DOT regulations. And there's a lot of those. They're extensive. They're actually called the Federal Motor Carrier Safety Regulations. And they're really extensive. And that's something we use in trucking accident type cases to prove our case. So, if Jeff, if you're driving a commercial vehicle, only do what the DOT regulations say. Because if you go, askew on that, then yes, you could face repercussions. If you are just a regular driver like me going to work and picking up kids, I think it is fine to have these type lights. The only situation I could see is, and it would have to be a bizarre situation, but like if you put on your brights and like somebody claims you blinded them with your lights, I've never seen that come up. I mean, what do you think about this?
I mean, it's a very unique question, right? But a great question. I think it's one of those things that I talk to my clients a lot about this. And in my opinion, what we do sometimes, the argument of a claim is like basketball. You dribble and you shoot, okay? It either goes in or it doesn't. And it's possible maybe that you're not liable, but if somebody else had these LED lights and they're following too closely behind you. Maybe there's another factor involved in a wreck that occurs, or it causes you to maybe be blinded in the rear view while you're trying to drive. I could certainly see an argument being made that, but for these LED lights that are blinding me. I mean, if you've ever been stopped in traffic and you've been behind a truck that has those LED lights, I mean, you almost look like a silhouette on the car in front of you because they are just that blinding. I don't know, but the argument could be made that depending on the circumstances of it all, that's an issue or a contributing factor in a wreck occurring.
Yeah, Alabama code has a section that's called Rules of the Road, and that is the list of all the statutes about how you can operate a motor vehicle. To be honest with you, I've never looked to see if there's a subsection about headlights, but Jeff's question, maybe I should go look that up. And Jeff, if you want to, you can search on the internet. Really, all you need to type in is Alabama Rules of the Road. And they're extensive, but you can word search in there for headlights. And I can't remember if there's any specific rules on that or not, but I don't think there is.
Those things can be really bright, though. So I see your point, Harrison.
Absolutely.
All right, now let's hear from Stephen. He left us a voicemail.
I was in the wreck, and the accident report is all wrong. It says I was at fault, which I wasn't. Is there any way I can get it fixed?
So, yes, is the short answer. But let me preface it with this. Crash reports are not admissible evidence in a personal injury case or any type of car accident case unless the police officer actually witnessed the accident, which is very rare. And even in situations where the police officer did witness the accident, a lot of the parts of the accident report are inadmissible. And the reason for that is hearsay. People have heard, lawyers object on the basis of hearsay, and essentially what the legal definition of hearsay is when there's somebody saying something that happened that didn't actually see it or didn't actually hear it. And that's exactly what an accident report is, assuming the police officer wasn't there. All the police officer is doing is looking at the scene and taking statements from witnesses. Perhaps he's reviewing surveillance video footage. But he's not a true witness to the incident. So whatever he is saying about it or she is saying about it is hearsay. Now, to the caller's question about the accident report being wrong, Harrison, you want to walk them through that?
Sure. You can always list it on the accident report is going to be the investigating officer who is who's there putting it all together, right? And they all tend to do their best, but it's not a perfect system. I mean, after a wreck has occurred, you're looking at two people, maybe more. You've got this one officer who's trying to get everybody's side of the story. I mean, if you've ever been in a wreck, it can really be chaotic. And so they do the best that they can, but it doesn't always mean that it's right. So I would start by contacting the investigating officer listed on the accident report, see what that looks like, if you can get in touch with that person and tell them your side of the story or why you believe it's wrong. It's also a great reminder, though, to get to an attorney early because there may be video evidence, there may be something else that shows that you're not responsible for a wreck. And if you are or aren't, I guess I should say, then hopefully we can get that changed. You may not even have to change the accident report. You may be just able to get enough evidence to present it to an insurance company and have them change their position.
I mean, that's typically what I do. We get accident reports that are wrong all the time. And I'm not, saying anything bad about law enforcement. They're doing the best they can. They're focused on getting people into ambulances and getting the roadway cleared for traffic. And sometimes the accident report is kind of low on the priority list. And I completely get that. But like I said, accident reports are not admissible evidence. So, car insurance companies, they always believe the accident report's true, no matter what. That's just how insurance companies operate. It's a government report. It must be true. But we've had cases all the time. I had one last year where it said our client was fault, but the other driver was speeding by more than 40 miles an hour. Of course, there were no witnesses that could corroborate that, but we went and downloaded the data off his vehicle. He was speeding by 43 miles an hour. That wasn't on the accident report, but that completely changed things, and we ended up resolving that case for a significant amount of money. We've had cases where we were able to get surveillance video, or that there was actually a witness that the police officer didn't put down who has a completely different story. So I'm not so much concerned with getting the accident report changed as actually getting the evidence we need to convince the insurance company, hey, this accident report doesn't matter, and here's why. Here's this witness statement, here's these photos, whatever it may be. So to that caller, you know, if you're injured in a wreck and the accident report's wrong, I wouldn't spend a whole lot of time trying to get an accident report fixed. I'd spend time hiring a lawyer to go investigate it and get the evidence.
So really, it sounds to me like what you're saying is it's not admissible in court, but the main reason you would want to get it corrected is for insurance reasons?
Yeah.
Or in case there's a lawsuit?
So if you've ever been through a wreck, you know if it's very clear on the accident report that the other driver is at fault, your insurance claim is going to go much smoother. You can get the accident report amended, but in almost every case, the insurance company's already got the original one, and they've got it red flagged.
So even if you do get it fixed, they may not have that.
It doesn't really matter.
Well, and I had an incident with a client who was rear-ended and forced right off of the highway, and the car that hit her then hit two other vehicles on the left side of the highway. And the accident report stated that my client was hit by somebody different, a vehicle that was unknown, and that's how she ended up over here. And the other vehicle, that they were two separate wrecks. And we were able to get the evidence, but also she spoke with the investigating officer who said, oh, okay, I see now. It was nighttime. Things were kind of chaotic, and he was trying to piece it all together. So there are those instances where that other vehicle never existed. It was just a mistake given everything that was going on.
Yeah. I mean, if you got an accident report and it says you're at fault or partially at fault and you really don't think you are, you got to go find that evidence to show you aren't. Both if you want to try to get the accident report amended, an officer's usually only going to do it if you bring some new evidence or whatever it may be. But to really convince an insurance company, you're going to have that evidence anyways, because they're already going to have it red flagged as a denial. Yeah.
Such wonderful information. Thank you guys so much. Such pros. We appreciate this information about personal injury and statutes of limitation. We look forward to hearing from you, our viewers, with any questions about legal topics. You can email us at questions@siniardlaw.com or call our voicemail 844-7000-LAW. Join us next Sunday night after the late news. Good night.
The preceding was a paid presentation by Siniard Law Injury Attorneys, paid for by Siniard Law Injury Attorneys.